Morning, all the participants. We welcome you all back to the session. Now, I take the privilege of introducing Dr. Ramani ma'am to you all. Dr. Ramani ma'am has a vast experience of 34 years of varied experience in R&D, academicians, and intellectual property, of which 15 years of experience is in patent preparation and prosecution with various jurisdictions. She received her JD and LLM from the then Franklin Pierce Law Center, USA. She did her postdoctoral research at National Aerospace Laboratories, Bangalore. She received her PhD from IISc, Bangalore, and her research was published in various reputed chemical engineering journals. She has received her BTech and MTech in chemical engineering from Osmania University, Hyderabad, and was a rank holder of the university. She is registered patent agent and trademark agent of India. She is a US attorney with a license to practice in Minnesota State Bar. She holds limited registration to practice with US Patent and Trademark Office. She worked for national and international law firms where she was mentoring and supervising patent engineers to ensure high quality of patent applications. She was a director at Intellectual Ventures and was working with investors from prominent Indian universities in the area of chemical engineering, material science, polymer chemistry, and other related chemical sciences. She held the positions of an IP counsel with Philips Electronics India Limited and a lead scientist with John F. Welch Technology Center, GE Bangalore. Before moving to IP and R&D, she was in teaching profession as an assistant professor at Dayananda Sagar College of Engineering, Bangalore. She was selected as one of the powerful women in IP in India 2021 for her commitment and contribution in creating, protecting, and securing IP rights by WIPF. At present, she is an associate partner at LexOpus. We welcome you, ma'am. We actually feel very honored and privileged to have you with us in today's session. Now the forum is yours, ma'am. Thank you, ma'am.
Thank you, Meena. So can I share my presentation? Will you make me a co-host?
Ma'am, I had made you, ma'am. You can share, ma'am.
Okay, right.
Yes, ma'am, we are able to see the presentation.
Yes, okay. Good morning, all. It's almost fourth day of session, I guess. So you must be tired, but it's a good learning practice for all of you. I assume that most of you are faculty members. First of all, I congratulate all of you because you are doing a wonderful job. You are the pioneers. You are really training the young minds and taking them forward in the right direction. I was a teacher, so I understand what the responsibility of teachers. So let's look at patent prosecution and how do we go about it. So it's almost fourth day, and I'm sure most of you will be already familiar with most of the terminology. I have some particular topics I was asked to speak on those, but I thought I'll just start with a little beginning, though it must be a repetition for you. Maybe it's a good catch up for you again. Okay, so let's just look at it. We started how the human endeavors started. We just invented a wheel first, then we made a bicycle with 2 wheels, then we went for a car with 4 wheels, and then now we have luxury sedan cars, right? So we kept on evolving. Similarly, we have, remember how our penicillin injection was discovered by Flamingo? He just found it as a mold on his bread, and now we have COVID vaccines, right? So we are evolving. So everyone, we are trying to evolve, and we are trying to invent something. So if you invent something, it's not very easy. I mean, to give up your hard work, right? You have to be protected by somehow. Your inventions have to be protected. No one should copy it just like that. So for that, the governments, the statutes decide to give a monopoly to all of you who invent something. So that is nothing but different intellectual properties, but we will concentrate only on patents. So this is a few very little introduction of patents, then we will go to our main topics. So you all must be knowing this. This is just a repetition. So basically, patent is a territorial right that is granted by a government authority for an invention, any field of technology. It could be IT, it could be chemical engineering, it could be physics, it could be chemistry, any science, you can have an invention. It can be a product, it can be a process, it can be an apparatus. And you have a protection for 20 years from the date of filing. And there are a few conditions to be met to get a patent. For every IP right, we have conditions, right? For designs, we have, for trademarks, we have some conditions. For copyrights, we have conditions like fixation, originality, and like that. For everything, we have conditions. So similarly, for patentability, we have 3 conditions. You all must be very familiar by now. First one is novelty, the second one is inventive step, and last one is industrial applicability. In some cases, subject matter also is a requirement. How do we do that? How do we start our patent process? We'll just start prior art search. Nowadays, we have a lot of facilities to do on our own. So we'll just do Google search or something like that on our own. If we still want further and we want professional search, we have people who can help us to do the patentability search. Prior art search is only novelty search. Novelty is no one should have done that. Patentability search is even they find out for the inventiveness. So what do you mean inventiveness? What do we mean by inventiveness? We have 2 applications. If we combine them together, a person skilled in the art will be able to come at that particular your invention. He would be able to arrive at your invention. That is called inventive step. So we will do a patentability search. We are happy that we don't have any issues. So we will move ahead. If you are capable of drafting a patent application, you will draft on your own, or you will approach a professional patent agents or patent attorneys to help you with drafting the patent application. The most important part of the patent application is claims, because claims are the ones which define the metes and bounds of the invention. How do you define your property? You just have a boundary wall, or you have a compound wall. Similarly, for your invention, you have we need a protection, and that protection is given in the form of claims. Okay, then we are done with the attorney is done. Generally, statutory forms have to be filed. That generally a paralegal will do. There are standard forms, form 1, form 2, form 3, form 27, everything have to be filed. That has to be prepared. And then we'll file the patent application. That is our duty. Then what happens? We are filed. Now patent office will take over from there. The patent application will be published 18 months. Generally, from the date of filing, it will be published within 18 months. Suppose in some cases, you want it to be published early. There is a provision for early publication by paying extra money. Then the patent application will be examined, and then we'll get a grant or we'll get a rejection, depending on that. Once you get a grant, is that done? No, we have to pay the fees. So generally how much it is, life is 20 years. Generally, no one will go up to the 20 years paying the fee, except for pharma industry. IT industry, they won't go at all, because the technology keeps on becoming obsolete very fast. So they may not pay. I mean, I'm not saying that they will not. They may not go ahead all the way up to 20 years. Whereas in case of pharma, we have to pay even till the last minute, because there is a lot of generic drug competition is there. So generally they maintain their patents for 20 years. This is a general procedure. Okay. Again, this same thing I have represented in conceptually. So we have an idea conceived, we get an idea conceived, then we'll go for patentability research, then we'll draft the application, we will publish, office action we will get, either we'll get a grant or rejection, and then we maintain it. How that will go? So we will, again, same thing in one more form, we'll file the application, it will be published after 18 months. Then after publication, we have something called as pre-grant opposition. Any person in India can oppose, saying that no, this thing you are not. So after the publication, he'll read the publication and he'll immediately file a pre-grant opposition. Then you, as a patentee, what you have to do, you have to file for request for examination within 48 months from the priority. Only in India we have to do that. In the US, once you you file the application, it's automatically taken care. Examination will be automatically taken care. Unfortunately, in India, we have to file request for examination within 48 months. Then it will be examined. Then we will reply. Right? As a patent attorney or as a individual, you can write. Examiner will say, look, your invention is not novel. Look, your invention is not inventive. Your claims are not very clear. They are not concise. They are not patentable under Section 3D. They are not patentable under Section 3E. Anything they can give. Then we, as a attorney or as an applicant, what we should do, we should immediately reply to the examiner within 6 months, which can be extendable by 1 to 3 months by paying extra fee. But right now, since we are in COVID, we don't have to pay any extra fee. The Supreme Court has extended the deadlines indefinitely to give some concession to the inventors in case they are suffering from the pandemic. So otherwise, we have to file the response to the examination report within 6 months. Again, then we'll have one more opportunity to be heard. So we can talk to the examiner. That is called hearing, oral hearing. nowadays we do oral hearings by video conferences. We need not go. So we'll have an oral hearing. Then again, we'll have an opportunity to explain the examiner what is our invention. So if we are convinced, if we are able to convince the controller, we get a grant. Otherwise, we'll get a refusal. If we get a grant, again, it will be open for post-grant opposition. Any person interested. The difference between pre-grant opposition and post-grant opposition is, for pre-grant opposition, it is only any person can apply. For post-grant opposition, it will be only a person interested can apply. For example, if it is a Pfizer or if it is another pharma company is got a grant, then only another pharma company can oppose. Right? And Reddy Labs can say, no, you can't. This is not patentable. This is so and so reasons. There are Section 25 of Indian Patent Act defines what are the conditions for which we can ask for a post-grant opposition. That's it. Once the grant, we get a publication, we'll pay the fee. This is generally. Okay, again, same. We have a filing, early publication, examination also. We can also ask for expedited examination, regular examination, express examination. If you want it faster, we have provision in Indian Patent Act to move forward faster. We have to see, this one is the first examination report, then we'll file the reply, then we'll get hearings, etc. Then we'll get a certificate or refusal decision. Okay, what are the formal requirements? We have to file Form 1, that is nothing but the application for patent. It has a lot of declarations. Suppose if you are using any biological material, you have to declare from what is the source, from where did you get the biological material, you have to declare that. Form 2 is a description. And Form 3 is did you file application anywhere in other than India? You have to tell the patent office. It's your obligation to tell under Section 8, it's an obligation of a patentee to inform the patent office where all we filed, what is the status, how many office actions you got. You have to keep on informing patent office. That is very requirement, and there are people who lost their patents in India because they did not disclose to the patent office. The next one, Form 5, is inventorship. Who is the real inventor? We have to disclose, or we have to disclose to the patent office. And Form 26, if you are filing, if I am filing on your behalf as your patent agent, you have to give me power of authority. Right? That has to be filed. These are the things we have to file along with the patent application. Then we have, what will happen? We just saw. Once patent is granted, we have to keep on paying the fees from 3rd year to 20th year. If you are by any chance, if you are delaying the fee, you can pay within 6 months, but you have to give conditions. Why did you fail? Why did you not file why did you not pay the fees? You have to give them the proper explanation. If you do not pay the fees, the patent will be abandoned. One more requirement in India is you have to declare, you have to file a Form 27 after the grant. What does it mean? You have to tell the government whether you are working on the patent or not. So you can't get a patent and you can't sleep over it, right? Patent is given to you, monopoly right is given to you for the public to get benefited because of your invention. So what you should do, you have to file Form 27. This is a little old information. It's not 31st March anymore. I think it's changed to September. So we have to fill Form 27 and tell them we are working or not working. So you can tell them you are not yet ready to commercialize or you are not yet ready to manufacture in India. You just explain them. There is a form, standard questions are there. You have to fill the form and file the Form 27 every year. Who are your licenses? Who are your licensees? Who are your sub-licensees? How much money you are making out of your business? How much imports you are doing? Everything you have to give in Form 27. Okay. This is just generally, I'm just briefly refreshing your mind before going into the tough topics. What I'm going to talk to you is a little more tougher. So I want to prepare the background for all of you. We know by now you all must be knowing it. Actually, if it's a virtual, if not for a virtual conference, I would have asked you to, you could have only answered these questions. Okay. How many types of patent applications are there? We know provisional application, non-provisional or complete specification, Paris, PCT, national phase, patent of edition, divisional application. I think you all must be knowing provisional. If you are not fully ready or you are in hurry, tomorrow you are a faculty member, tomorrow you have to present in a conference, but you want, if you present outside, you cannot get novelty, right? So you have to file a patent application. So quickly you want to get a date, priority date, then you file a provisional application. Your data is not yet ready, you need some more time to do, but you want to save the date, then you file a provisional application. Provisional application will not be valid unless you file a complete specification within 12 months. That is called complete specification will have claims. Provisional application will not have claims. It only just some description, some material. You can put all the material in that. That will be provisional application. For non-provisional application, we'll have claims. It's a proper complete application. Then convention application. India is a Paris Convention member. So if I file in India, I have 12 months to enter the other countries of Paris Convention. But Paris Convention will give you only 12 months. So then WIPO has come up with PCT, Patent Cooperation Treaty. So you will have 30 to 31 months to enter the national phase. So you can assess, we are a small faculty members, but for big businesses, it's very important. They can assess whether really I need my invention to be patented in US, should I patent in Europe, Japan, China. I'll have time. See, when you have to file in different countries, especially European countries and Far East countries, big problem is translation. Translation cost is extremely expensive. So all these costs you can push till 30 to 31 months, such that you can buy, especially imagine a startup. Initially, they won't have funds, right? They can't afford to file in other countries. So what they can file a PCT application. It's absolutely business decision. They decide account based on the business decision. So what do you mean by PCT national phase application? When you enter the nations after 30 months, that application is called PCT national phase application. Patent of edition. What is patent of edition? We have filed a patent, we have got a grant, or is all about to be granted. Then we invented something very little. It will not be able to hold itself as a complete application. But I want to save that particular modification or edition. So in India, we have something called as patent of edition. So you can add that and attach to the mother. The main patent is called parent application. You can attach this as a child to the parent application, and the child will die along with the parent patent. That is patent of edition. Then we have divisional application. We all know that we get monopoly right. So one patent application is for one invention. You cannot have 2-3 inventions clubbed in one application. It will be unfair. So that is called unity of invention. Even PCT will reject. It says unity of invention. You have more than two applications. So please divide them and we'll file different applications. Those are called divisional applications, right? Okay. Then suppose we want to file outside India. It's extremely important to take you have to file a foreign filing license. Suppose you are an Indian inventor and you want to file in the US. So there are two options available for you. First, you file in India, wait for 6 weeks. If there is no news, no letter, anything from patent office, you can go ahead and file your application anywhere. So you file, wait for 6 weeks. Or you don't want to file in India at all, you directly want to file in the US. For what reason? Depending on, again, it's only business decisions. If you want to decide and file in the US directly, then you have to apply for foreign filing license, FFL. It's called foreign filing license. Two options. One is file in India. Maybe that is the best route, right? In India, filing provisional application is not very expensive. So file in India, wait for 6 weeks, then file anywhere outside. Or if you don't want that, you can directly apply for FFL and then file anywhere you want. But it's compulsory to do this. You cannot file an application without these things outside India. It can lead to abandonment of your patent. Okay. Then, how do we apply the foreign filing license? Very easy. There is a form called 25. You give all the details of the invention. If it is normal invention, nothing to do with atomic energy, nothing to do with defense, nothing to do with the atom bomb, something like that, nothing to do with national security, you will get quickly, without any problem, within 6 weeks, you will hear from the patent office. Or we will not hear. No information is positive information. But if there are secrecy directions are there, then it may be delayed because this we'll see in the next slide more. If there are secrecy inventions, the controller has to communicate to the central government. If central government says no, only you can move ahead. Okay, so controller will not be able to take a decision. Controller will say, hold on, it is under secrecy. So this relates to threat of the national security. In that case, it will go to the central government. They decide, oh, really, whether it is a threat to the security, yes, then stop. If it is not, let him go ahead. Okay. So secrecy directions are issued. Either there will be a delay or there may not be a permission at all, because national security is at most important. Secrecy directions are reviewed by central government at intervals of 6 months. So central government will not do every day on daily basis. They'll do every once in 6 months. So they combine all the applications and send to the government, and they revise, they review twice in a year. Okay. Or if you are really in hurry, then you can make a request. Please consider, I am in hurry. I want to see whether it is for my invention falls under secrecy. So this is for you to get refresh your memories about the patents and all. So now let's start our real representation. Okay, what are secrecy provisions? So, okay, Section 35 of Indian Patent Act. I never give any numbers on this thing because I don't. It will be too much to remember the section numbers. Not necessary for you also. Okay, controller may identify a patent application as a secret if it is relevant for defense purposes or up to his discretion. Okay, it's controller's discretion. If it is definitely something coming from ISRO, something coming from DRDO, something come from HAL. So these are all the very hubs of secret inventions, right? So the controller will have to look at them very carefully. So applicant is prohibited. You cannot publish, you cannot communicate to any third party such inventions unless you hear from the government. Patent application is then forwarded to the central government, right? First, controller will look at it. If he's in doubt, then he'll immediately pass it on to the central government, and central government will check whether it is prejudicial to national interests or not. If the central government agrees, you cannot proceed further. Restrictions will be enforced. If the central government feels that a controller is wrong, it's nothing to worry about the security of the country, then the restrictions will be lifted. Government will notify the controller not only now. See, you sometimes even up to the grant, the government can follow and they can say, yes, it is dangerous to publish this application. In such cases, you will not be able to proceed further. It doesn't mean that you will not get a patent. It will be examined, it will be checked for novelty, inventiveness, everything. The patent will be granted, but it will not be published anywhere and you cannot disclose to anyone. Okay, central government can use, or any third party assigned by the government, they can use the invention without disclosing to the public. It will not be published, it will not be printed or published anywhere, it will be secret. Okay. Even central government will not disclose this information because if at all the invention is related to the security of India, then it will not be defined. It will not be published. What do you mean? How do we define security of India? Security of India includes material that relates to fissionable materials, like anything, any nuclear kind of material, relates to traffic in arms, ammunition, implements of war, or it is taken in time of war or other emergency in international relationships. Any of these things, these are security of India. Any of these conditions, your patent application is doing anything with one of these conditions, your application will not be, it will not be published. It may be granted, inside, we will not know anything about it. You as an inventor, you will be informed, but it will not be disclosed to the public. Why is that? Because national security is kept at highest pedestal. Yes, we understand. As inventor, it hurts us. We work so hard. We want to have a patent. We want to commercialize it. We want to license it. We want to make money out of it. But if you have to balance between your interest versus national interest, national security is at the highest pedestal. Okay, every Indian resident has to inform and keep it secret till the authorities give permission to disclose outside India. So you cannot file outside India. Okay, now we don't have to feel that bad. We are compensated, right? Invention is just not happen just like that. You have worked so hard. So you have to be compensated for that. So you will be compensated by central government, but we all know how much government pays compensation. It may be very little money, but still we will get some solatium for our hardships during the process. So it's really not fatal. So only thing is you will get a patent also, but it will not be disclosed and you can't file outside India. It's not only for India, right? This is practice of every country, right? For every country, inventors are important. We have to protect their invention. We have to protect their intellectual property, but not at the expense of national security. Okay. One issue is still there, which is bothering and which needs to be looked at by the policymakers is multinational companies. Nowadays, I work for Philips, right? While working with Philips, my co-inventors are there in the US. My co-inventors are there in Europe. So how do we match? How do we do this? So still things are not very clear. I looked at some case laws. Unfortunately, I could not get any case law for this case. But things are not very clear. If many inventors having different citizenship, what will happen? If US also demands that he has to file in US first, Europe files, India, everyone, if they file, what will happen? This is an unresolved issue. Still, we are looking at it. It's still under debate. How do we go about? But time being, as an Indian inventor, it is your obligation, it is your duty to first let the controller decide whether your invention is secret, whether your invention falls under secrecy directions or not. Okay, so this multinational issue has to be addressed. They are all looking at it. Okay, so that is our secrecy provisions. Section 35, I think, in the Patent Act defines the secrecy directions. Okay, now the next topic we will be talking about is rights conferred by grant. So you worked so hard, it's granted, now you are very happy. So what all rights you can get by getting a grant? It gives you exclusive right and protects from infringement or unauthorized use. So no one can use your invention without your knowledge, without your permission. So that is called infringement. We will see more case laws. I have given you some case laws so you'll understand. If it is a product, patentee can prevent third parties from making, using, selling, or importing that product. Suppose you have a patent and it is for a product. So you cannot, no one can make, use, sell, or import your product without your authorization. So sometimes I'm a chemical engineer, right? So we have process patents also. We realize that patents can be for a product, can be for an apparatus, can be for a process. So if it is for a process, patentee can prevent third parties from using the process for sale, selling the product obtained by the process. So no one can use your process, make a product and sell that process. Sell that product. That is also prohibited. Understand? Product means he cannot sell. If you are filing an application and you got a grant for a process of patent, your competitor cannot use your process to make the product. Okay. What are the different types of rights we have? We have a right as an inventor to exploit the patent, to assign or license the patent, to surrender the patent, to apply for patent of addition, to stop infringement. These are the rights we are given as an inventor after the grant. What do you mean by exploiting the patent? So you have the right to manufacture, to use, sell, and distribute the patented product. Say, if it is a product, you can manufacture, right? You can use it, you can sell it, you can distribute, right? If it is a process, then you have the right to authorize third party. So sometimes you may not be really, you are an inventor, you are working for a university, right? And you won't be having the facility to manufacture. So you can authorize or you can license, you can assign your invention to someone and let them make it for you. These rights can be enforced by the licensee, assignee of the patent holder. Suppose, what do you mean by that? You are a patent holder, you are a patentee, you have a grant, and you assigned or you licensed to someone. So your licensee will also have the same rights as you, provided you have every document, license agreement is written in properly and it is a contract signed by both the parties and you have a valid license. Your licensee can also enforce your rights. So because you gave him your rights by licensing. So the next one is to right to assign and license. What is the difference between assignment and license? Tomorrow I think you will be seeing in more in detail. Assignment is something which you give away. You assign. So you will not, as an inventor, you will not have any right over it. You assign your invention to someone else. Okay. Generally, we will not advise that for the university faculty members. We will generally only give a license. How many types of license are there? Most important licenses are two types. One is non-exclusive license and another one is exclusive license. What do we mean by exclusive license? Exclusive license is only for one person for one area. I mean, exclusivity can be for different parameters. Suppose you want to give your invention only for, you want to give an exclusive license to someone only in India. Possible. Same license you can exclusively give in the US. So territorially, it's possible to give exclusivity. Okay. Similarly, you have a detergent solution. So you can give your detergent solution patent to someone in automobile industries. So we can use only in automobile industries. You can give the same invention to someone to use in the domestic appliances. Okay, so you can have exclusivity based either on geographical territory or based on the technology area they use. So up to you. So that is called exclusive license. You can also not use actually unless you ask them that I want to use it. So that is called carving out. Okay, this is tomorrow you'll be doing. It's a licensing itself is a big topic. So in licensing, while preparing the documents, you should be extremely careful. If you want to give an exclusive license and you also want to use, then you have to have a carve out. You have to tell them, I also want to use. So you need some professional help to draft a licensing agreement or assignment agreement. See, as long as everything goes smoothly, absolutely no problem. Your licensee will be happy. But tomorrow, if some controversy comes, we need something to fall back, and that fallback is nothing but your agreement. So you should please be extremely careful if you are drafting the licensing agreements. So you have to have some professional help. Okay. Patentee can assign or grant licenses. So as a right, he has the authority. He can grant license or he can assign for manufacturing and distribution of the patented products. It's not necessary that everyone will have the provision to manufacture. So what they can do, they can assign and they can license it. Okay. If there are more, suppose there are more than one owner, right? Quite possible, right? You are from chemical engineering department, someone else may be from the microbiology department, and both of you work together and both of you came up with an invention. So you both will be the co-owners. You and he or she will be a co-owner. So the license has to be assigned by both of them. We will see a little later. So if you have more than one inventor, both the inventors have to agree for the license agreement. Okay, if I am there and you are there and I go ahead and give the license, it will not be valid. You also have to sign. Request for license has to be authorized by the controller. So we decided everything, we have written the licensing agreement. That licensing agreement has to be authorized by the controller. Patent licensing, especially if you're talking about patent licensing, that has to be authorized by the controller. So this is the second right. We have right to assign or we have right to license. The third one is right to surrender the patent. Okay, we got the patent. We are happy with it. Now we don't want to continue anymore. One way of doing it is don't pay fees. It will be abandoned. But one other better way is surrender the patent. So why people will do this thing? So if you surrender the patent at earlier, before it is reaching its 20th year, then it will be open to the public and they can use. Some big companies do that. They open the patent and they say, we will not enforce. You use our patents. Right? We have patents, we pay the fees, but we will surrender the patents. So you are free to use. If it is surrendered patent, anyone can use freely. Okay. So the patentee has the right to surrender his patent after seeking the permission. So he can't just like the do, there is a format. So he has to write to the exam controller and say that I want to surrender the patent. Then controller will advertise, and then anyone who wants to take the patent, they can take it. Right to apply for patent of edition. We just understood, right? I just explained what is meant by patent of edition. So as a patentee, you can keep on adding the patent of edition. So patentee is granted the right to the modified invention after the notification of the acceptance comes out. Generally, you can't, but as a patentee, you want to add the modification, you can do that. Okay. Right in case of the infringement. This is the most important right we have. So we will do more case law about it. Okay. So what do you mean by infringement? When any of the rights of the patent holder is violated, then it is termed as patent infringement. I have a patent. So someone else comes and they use my product or they use my process to make the product, then they are infringing my patent rights. If the patent invention is used, manufactured, sold for commercial purposes by any purpose, then they will be accused for patent infringement. No one can use, sell, manufacture the patented invention. In case of infringement, patentee can approach either the district court or high court. Right? But here, patent office will not come into picture. So, right, patent office job will be done by when we finished our grant. We got a grant. Now we started manufacturing. We came to know that someone else is using our patent. Then whom should we approach? We should go to a district court or high court. Still, we are not happy. We can go all the way up to Supreme Court and then can appeal. Okay. If the person is proven guilty of infringement, the courts will either grant permanent injunction, damages, or both. right? What do we mean by that? So it's not easy. You go and say that he is infringing. You have to prove you have to provide lot of evidence. You have to convince the court, yes, it is being infringed. Then the courts will either give permanent injunction, they'll ask them to stop completely, or they'll give you the damages, they'll do the calculations and how much loss happened because of his sale, how much you suffered. They do the calculations, they'll either give the injunction, they'll give the damages. Depending on the severity of the case, this will happen. And the most of the infringement happens in case of pharma industries. Till now we learned that, right? What we learned, we can as a patentee, we can exploit the patent, we can license the patent, we can assign the patent, we can go behind the infringers, we can have a patent patent of edition, we can also do surrender the patent. So does that mean that it's absolute right and you can get absolute monopoly? No. You have to, again, every time there is a balance, right? So the Patent Act also balances individual rights of patentee and interest of general public. Especially this is true for developing countries. So you are a patentee, you have rights, but if I have to weigh between your rights as against the general public, I have to weigh both and then decide, and then the courts will take a decision. Okay. Why is that? The purpose of Patent Act is to encourage development of technology and innovation, not to impede, not to stop someone, not to cause harm, right? Why is the monopoly given to you? Because of the monopoly, you will publish, you will disclose it. So others can understand and they can take it forward and move ahead, right? Technology moves on. If it is kept closed, like what is the difference between patent and trade secret? Trade secret is kept secret, right? But no protection for that. As long it can be protected as long as it's kept as a secret. Whereas patent is not like that. Patent, you apply, it's published, it's open to the public. And if someone wants to use, they can come and approach you. And then you can talk to them, have an agreement, and you give them your technology. They'll practice the technology, right? So you have rights, but it will not be absolute monopoly that nothing else can be done. There are some exceptions. So let's see what are those exceptions. Excuse me. So what are those exceptions? So exceptions to rights conferred by grant are, there are some exceptions as well as limitations. The first one is experimental or research use. If someone wants to do experiments or they want to use your patent for research use, they can use it, right? They'll not be infringing, okay? But I mean, again, they can't say research and they can't sell your product, right? Research is only without any monetary benefit. It is to take the invention or take the technology forward. So if that case, it is not an infringement. So that is called experimental or research use. Still, again, we don't have too much of case law at all, but there is an exception. If someone wants to use it for experimental or research use, they can use the patented invention. You can take that, you can use it, you can make the same product in your lab, and then you want to do more experiments possible. So that is called experimental or research use exception. Okay. For obtaining regulatory approval from authorities. So I will take you through more detail. Basically what it is, suppose you are a generic drug manufacturer. You want to make a drug, not branded company. You have a generic drug company and you want to make the drug. So what do? We will have to wait for the patent to come expire, right? And then start. Then it takes so much of time, right? It takes so much of time to do the experiment, so much of time to get the approval, right? Any pharma product needs to go through so much, especially the drugs need so much of clinical trials, phase 1, phase 2, phase 3 clinical trials. They have to go through a lot of mill. So what the government said is, if you are a generic company and you want to do experiments before the patent is expired, before the patent of the branded company is expired, you are free. Only for obtaining regulatory approval, right? Not for making and producing and selling. That no, but you can bring it, you can use the patented product, you can make the product without infringing, provided this is only for obtaining the regulatory approval. Exhaustion of patent rights and parallel imports is another exemption. Exhaustion of patent rights. What does it mean? Suppose I have a patent on a washing machine. I sold you. That's all. My patent rights are exhausted. right? So I can't ask you, why did you take the washing machine and given it to your friend? I have no right. So once the patent product is sold to someone, his rights are exhausted. It's a big topic again in itself, so we will not go. There are national exhaustion, regional exhaustion, international exhaustion, so many types of exhaustions are there. So that is you can't keep on going behind. Once sale is done, your patent rights are exhausted. Similarly, parallel imports. So you cannot import, you cannot stop someone importing from other country if you don't have patent from there. Okay, so we will see a little later more in detail. So parallel imports are also possible. This is an exception. Compulsory licensing. Compulsory licensing is the government will interfere and tell the patentee, you give the license. So patent, I have a case to explain you more in detail. Compulsory licensing is in case of public health issues. If you are not practicing your invention, then the government can interfere and tell the patentee, please give license to someone else who can make in India at a cheaper price. This happens with a multinational company. Suppose they have a patent here, they're not making at a competitive price, and they're not making in India, they're importing to India and they're selling at a higher price, and we can't afford, right? Our India is a developing country, and public health is the constitutional obligation of our country to provide health to the to her citizens. That is her constitutional obligation. So the government can interfere and can issue a compulsory license. Use or acquisition of inventions by government. You have done something, you have done a wonderful job and you got an invention. Unfortunately, if that invention is useful for the government, so the government can use it. Sometimes they pay you, sometimes they may not pay you, but they acquire your invention and they can use it on their own. Use of patented invention on foreign vessels. Suppose in the transit, they are transiting and they're touching Indian borders. That is not a patent infringement. So now let's look at each exception. Experimental or research use. See, when I say these exceptions, there is a very thin line. Okay, it's not very black and white area. It's a lot of gray area. So there will be a lot of controversy happening. So how do we say? Where do we draw a line is a big controversial matter. Okay, research exception permits use of a patented invention or for experimental purposes without infringing the rights of the holder. Right, but one thing we can keep in mind is monetary benefits. If it is really done for research, or really done for teaching the students, really done for experiment to understand the invention, then fine. The minute the government or your patentee sees any monetary transactions, then you will be at problem. So research exception permits use of a patented invention for experimental purposes without infringing the rights of the holder. What is the objective? Why is this exception? Basically, it is to promote R&D and must not impede or hinder higher education and research, right? So someone has patented, that doesn't mean that you stop, that there is a dead stop there. No one can further move. No, I take your patent, I'll do more and I'll add more if possible. Just the experiment. Okay, when I want to patent it, then that's an issue. Right now, to understand or to develop more things, I will go ahead and use your invention only for research or experimental use. Interpretation of experimental use, scientific research is exceptionally broad, right? And general, and no limitation to scope and extent of research and experiment in the Act. Unfortunately, our Patent Act did not really define, it's very broad, experimental use, scientific research. So they are very broad. So if at all there is a controversy, we will have problem because we don't have any strong rule or strong say in the Act. No distinction concerning the nature of the organization conducting the experimentation or research. It may be a commercial, it may be an NGO, right? If it's an educational institution, fine. If suppose an invention done by a multinational company is taken by another multinational company, how do we do that? Can we really say that it is only for experimental research? I understand if it's by university. Yes, university, the more objective is to promote research, the objective is to impart the higher education, fine. But another multinational company, how do I justify? That's still a question. So the Act really doesn't define very clearly, and the interpretation are very, very broad. This I explained. We'll see what exactly it is. For obtaining regulatory approval from authorities. Okay. Making, constructing, using, selling, or even importing a patented invention are allowed for obtaining regulatory approval from authorities. What do we mean by that? I already explained. So objective is that the manufacturing of such products should not be delayed due to time taken for obtaining marketing approval and to enable submission of reports to a regulatory authority. This is basically for pharma, drugs, right? Mostly 99.9% this exception is only for pharma products. So you want to release a drug, right? You are a generic company. You want to make a generic product, right? Generics are very, very cheap. Why generics are very cheap? Because brand have spent all the money, so many years, right? For a pharma product to reach from research to a drug, it takes anywhere between 10 to 15 years. And it takes billions of dollars, right? Clinical trials, phase 1 trials, phase 2 trials, phase 3 trials, so many trials they have to do, and they spend so much money, brands. So as a generic manufacturer, you don't have to do all those things, right? They have done all the hard work. So you take their product, reverse engineer it, or add something, and you start making. That's why generic drugs are cheaper than the branded. All the experimentation, all the research expenditure has been borne by the branded company. So, but anyway, it's going on. It has to be, otherwise they'll have monopoly branded drugs. India is very particular not to give the patents continuously for one product, right? Section 3D, maybe you would have already heard in your 2-3D classes, right? That is called evergreening of patents. So multinational companies or foreign companies cannot keep on getting patent for a delta invention, right? The best case is Novartis case. You all must be familiar with Novartis case, right? They have used that imatinib. Then they came up with a salt, beta-crystalline form, and they said the beta-crystalline form is very stable. It has a high solubility. Then the Supreme Court said no. For pharma products, to get a patent, it has to have therapeutical efficacy. It should, suppose you are taking drug for 1 week. If your invention is making that you can take the drug for 1 day, yes, we agree. But you can't say that it tastes good, it dissolves in water very nicely, so give me a patent. So under section 3D, it will not be granted. Okay, that's a separate thing. So basically, what did the governments say? Suppose you are a generic drug manufacturer and you are waiting for 20 years of the branded drug to expire, right? Patent will expire at the end of the 20 year. So before the 20 year expires, you keep all the things ready. You get the approvals, you get the tests done, everything. And the day 20th year expires, you can enter into the market, right? So there will not be any delay. That's the reason why we can allow you to use the patented products. If necessary, import it from outside and use it in the country. Even if the branded has a patent, we will allow you only for getting the regulatory approvals. Example, this is the example I had been telling you about. For example, manufacturers of generic drugs can use the patented inventions for development and submission of information required to public health authorities. What do you mean by that? Maybe we may have to give the clinical data, right? We may have to do tests. We have to show the stability of your drug. We have to do other kind of things. All those things we have to submit to the public health authorities. So you can do that without patent owner's permission and before the patent protection expires. You don't have to wait for 20 years. Keep all the things there. Don't start making. Generic drug manufacturers cannot make, but they can do all the homework. They can go to the authorities, they can approach them, they can get the approvals, they can keep everything ready. And the day the 20th year expires, the branded drug patent expires, they can enter into the market. The generic producers can then market their version as soon as the patent expires. This provision is called Bolar-like provision. These are called Bolar provisions. There is a case in the US. One of the parties, his name is Bolar. So this exception is called as Bolar exception or Bolar-like provision, where it is allowed to use the patented product, to import the patented product, to reverse engineer the patented product to get the regulatory approval. Again, no monetary benefit should be there. You cannot produce, you cannot sell unless the 20th year expires. 20th year, the patent expires. The other one is exhaustion. Once a product of patentee is marketed, either by him or by others with his consent, the patent rights of commercial exploitation over the products are exhausted. So I make something, I sell sell it to you. You are the owner now. I can't ask, why did you destroy? You can burn, you can throw, you can donate it to your friend, you can do anything. I have no right. My right as a patentee exhausted with the first sale. I sold you, that's it. I can't. Otherwise, what happens? I keep on having monopoly on you, your product, your friends who are bought from you. So that's not possible, right? So that is stopped. Okay. It is also possible to import the patented products from the licensee of the patentee in any country without the permission of the patentee. I am a patentee. I have my licensee in China, right? I'm making in India. My licensee is making in China at a cheaper price. So you can import it into India from my licensee, right? My licensee in China, it's possible to import. This really basically helps you to control the price. Otherwise, what will happen to me? I'll just increase the price to whatever possible. I just increase. Whereas the same product is made at a cheaper price in a country where I have a licensee, I can get it from my licensee. This is called parallel import. Okay. For example, if John acquires a patent over a washing machine in India and China, okay, just an example. I have some John. He has a machine. He has a patent in India as well as in China. So Jack can import the washing machine into India from China without infringement if he purchased directly from John or his licensee or assignee, or if he got it from a compulsory license. Okay, there is some national threat and the government said, okay, I am giving you compulsory license, then also you can import it. But if China doesn't grant, you cannot, because I have a patent in India. I don't have patent in China, so you cannot, because I am a patent holder. You cannot import into India from China if there is no patent in China. That is a parallel imports and exception. These are all the exceptions. One more exception is compulsory licensing. This is done by government. It's not done by anyone. Compulsory license can be granted in case of few conditions. What are the conditions? Non-working or insufficient working. As I told you, you patent it, you sleep over it, you don't do anything, then, and your invention is very useful, very important for public health or very important for public interest. So the government can interfere and say, since you are not practicing, let us give your invention, let us give your patent to someone else. So that is called compulsory licensing. Compulsory licensing is done by government only under certain conditions. Okay, government also can't take away your invention and ask someone else to make it. It can be done only in case of non-working or insufficient working. That is the first condition. It can also be any of these conditions, not available to the public at a reasonably affordable price, right? Especially drugs, if they are not at affordable price and they are exorbitant, the government can interfere. Non-satisfaction of reasonable requirement of the public. So you are only making this much. It's not enough for our people. It's not enough for the public. Then also government can ask to increase the production, public health, and national emergency or extreme urgency, public non-commercial use, export a patent. And if you suppose we want to send some drugs to some other country where they don't have manufacturing capacity. These are all generally compulsory licensing. Whenever we are talking about all these exceptions, they're mostly related to pharma. Okay, so export a patented medicine to a country having no manufacturing capacity or inadequate manufacturing capacity. So I want to export to the country, maybe Brazil or maybe some other Bangladesh. They don't have manufacturing capacity. The people are dying there, right? We want to give them some drugs, we want to send them medicines, and you have a patent in India and you are not able to do that. Then government can jump in and say, give to someone else, make the drugs and can export. Refusal to grant licenses on a reasonable terms. Suppose you are very stubborn, you are refusing. Generally, it is at arm's length, right? So when someone comes to you and approach that we want to make this product, please give us license. Then if you are really, being smart and saying that you learn terms and conditions and you want to have 50% royalty, 75% royalty. If you have some unreasonable terms, then also government can jump in and then can say that please issue a compulsory license. Government can issue a compulsory license for your invention. Okay, so this is important feature. Especially this is very useful for the developing countries. Interference of government to safeguard the public interest as against the interest of a patentee. So not non-working or insufficient working, not available to the public at affordable price, not enough quantities are available, public health is at stake, national emergency is at stake, and you are not using it at all, and you are refusing to give to anyone else at reasonable terms and conditions, then we can ask for a compulsory license. Use or acquisition of inventions by government. Okay, naturally government has sovereignty right, they have every right. So central government has power to use inventions for its own purpose between the date of filing at any time during the patent is in force, and royalties paid is not more than the adequate remuneration taking into account of the economic value of the use of the patent, right? So it's a property, and if the property comes in the way to make a road, what will the government do? Right, the government will acquire a property and they'll pay you some money and they'll use it for making a road. Similarly, patent. If the government feels that your invention, starting from the date of filing to the expiry, if the government anytime feels that they have to use this invention, they can use it. They'll pay royalty, but that is not according to what you ask. That is according to the economic value. The government decides the royalty. Right? This is another exception. So you have rights, you have monopoly, you can stop everyone, but these are the exceptions. So with this, we complete the second topic, that is rights of grant. So what did we learn now? Till now, first we learned about secrecy directions, right? Secrecy directions are not only for India, every country has secrecy directions. So you have to file a foreign fee license. You want to apply outside, what you should do first? First file in India, wait for 6 weeks, or you don't want to file in India, apply for FFL, foreign filing license. Apply and then get the foreign filing license and move on. When you apply for foreign filing license or when you file an application, the controller will look at the patent application. If he feels that it is threat to national security, he will immediately inform the central government and he will not let you proceed further. That is secrecy. That's what we learned. The second topic we learned is rights of grant. The minute I have a patent granted, I have so many rights. I can make, I can sell, I can license, I can do anything. But there are also some exceptions, keeping the public interest in mind. What are the exceptions? Some exceptions we saw: experimental use, government use, regular authorities, parallel imports, exhaustion. These are all the exceptions for your rights. Okay. Right. The next topic is rights of co-owners. What do you mean by co-owner? We just said, right, not necessary that you are the only one who will be. Sometimes you may be the only inventor. You're working in yourself and you got a patent. Perfect. Excellent condition, actually. If you say that you are the only inventor, there is no problem. But if you have more than one inventor, there are pros and cons. More inventors, more creative ideas, more faster the invention comes out, much bigger perspective can be, because 2-3 minds can work, right? Excellent. But there are also issues. So what are the rights of co-owners? More than one person can apply for a patent. Together, they can apply, right? You and me, both of us together can apply for a patent. Upon grant, these applicants get joint ownership or become co-owners. Like we both will be the co-owners. There are risks and legal ramifications involved because of the joint ownerships. So there are everything keep in mind. As long as it goes smoothly, no problem. But if at all any controversy comes, then we need to have some fallback position. Okay. What are the rights of the co-owners? Each co-owner is entitled to an equal and undivided share in the patent unless there is an agreement to the contrary clearly mentioned owner. Like it's exactly like a property. If two people are buying a property together, they are co-owners, right? So they get equal and undivided share by default. That is a by default. But if we have a written agreement saying that A will get 75%, B will get 25%, perfect. No problem. If at all any controversy comes, we have the agreement with us. If there is no agreement, both owners will have equal and undivided share. That is 50%, 50%. So be very careful to understand what you want in future. So just don't be happy today and apply for patent together, two of you. Think tomorrow. So let's write everything. Best way is to draft an agreement saying that he will have this much share, he will have this much share. That's better. If you don't, by default, it will be 50%, 50%. Tomorrow you can't say that I spent more money, I invested a lot of time, I should get more share. Not possible unless you do that beforehand. For example, two groups are working, right? Maybe two groups A and B are working from two different universities, two different labs, or two different countries, whatever it may be possible. A and B are working. In A group, there are 4 inventors. In B group, there is only one inventor. So how do you share? A will get 50, B will get 50. Not that A will get 4 shares, right? A will be considered as one inventor and B will be considered as second inventor, co-inventor, and both of them will get 50% share. Okay, unless, yes, if you want more share or if you want more clarity, A should get 4 parts as against B 1 part, possible. Write it down. It has to be in a writing. It has to be in a contract. So each co-owner shall have the right to prevent third parties from making, using, selling, offering for sale. Same as how a patentee will do. Each co-owner will have. I can stop, you can stop the third party from making, using, selling, offering for sale, or importing. Everything we can do as both of us together. Each of us have the rights to stop. I can stop. If I don't, you can stop. Possibility, no problem. Each co-owner is entitled to equal patent rights and can independently commercialize the patent without seeking permission from the co-owner. So I can, both of us got a patent. So I can manufacture in one place. You can manufacture in one place. Both of us can commercialize. What we can't do, we'll just see the next slide. Both of us can commercialize independently without asking permission. So we got a patent. I have money. I'll start production. You have money. You start production. Absolutely no problem. You have, you are a co-owner. I am a co-owner. Both of us can do it. What we can't do is, but it is basically a movable property. So same, how you apply to the property, it will be applied to the patent also. So proper care is needed while entering into the joint ownership of a patent. So when think before. That's what basically this whole slides or whole law is saying is, please be aware of the problems that can come later. Proper care is needed while entering the joint ownership of a patent. A license for such patent shall not be granted to any third party by any one of them. Okay, I can manufacture, you can manufacture, but I cannot license without your approval. So to license to third party, to assign to third party, both the owners have to sign the document. A share in the patent shall not be assigned by one of the owners without the consent of the other owner, right? This is what I said. You can commercialize, you can do anything, you can stop, he can commercialize, he can stop others, but none of you can independently assign or license your invention without permission of your co-owner. Okay, suppose A and B are co-owners, right? If A wants to license to patent his patent to X, A must obtain B's permission, right? Both of A and B together can license to X. Suppose B is not willing. B says, no, I don't want to license to my invention. I want to keep it. Then no other, we didn't have any writing right. Did we specify in our licensing agreement, or whenever we started, did we say that I can take individually decision to go ahead and commercialize our license? I didn't have any such things. So in that case, A have to go to controller, seeking his power to direct B to agree to the licensing. But it is at risk, right? It's at completely controller's discretion. So A will approach and say, please, controller, ask B to agree to the licensing. A controller can do only so much. He will look at the facts, he will try to talk to B, and B doesn't say, he can't force, right? So it's his right also. So controller is empowered to give the directions to joint owners regarding the sale or lease of the patent, grant of license, etc. Controller is empowered. Approaching the controller for directions may be uncertain and time consuming. So this complexity can be avoided if they both enter into agreement about how they would exercise their licensing rights. So let's think before the problem arrives. Let's think thoroughly and foresee what can happen tomorrow. Okay, now we are friends, right? Actually, patent is like a property. You can your next generation can inherit your property, right? You may be friends. You and A and B may be friends now. After A's death, it will go to his child, and he may not be okay with continuing with B. He wants to sell license to someone else. So please think through properly and document, prepare an agreement. How do we share our licensing rights? It's possible to do that. Okay, that is the right of co-owners. So what did we learn with the co-owners? Co-owners both have authority to stop the third parties. Both have authority, both can commercialize a product, but both can only together license or assign. One cannot license without others' permission. Okay. Term of patent. So the filing, right? We all know that it can go for 20 years. So if it is a, if it is filed under national phase under Patent Cooperation Treaty, the 20 years will begin from the international filing date. So patent has term of patent is, the next topic is the term of patent is 20 years. Okay. Now what happens? Now we got the patent. Are we done? Are we happy with that? No. Once patent is granted, it has to be maintained. It has to be renewed. For that, we have to pay the renewal fee. Each country will have their own fee structure, and there are different entities, right? There is an independent inventor, single inventor. There is small entity, large entity, and large entity, small entity, medium. Now I think they merged everything, and then we have only two types of fee structure. Before we used to have so much. I mean, if you are independent inventor, only single one, and then you have one kind of fee structure. If you are a large company, there are definitions. If your turnover is more than 250 crores, you are considered as medium enterprise, something like that. There are a discretion depending on the size of your organization, number of employees you have, you can pay the fees accordingly. Okay. So payment has to be done to the patent office before the expiration of the relevant year. For example, if you want to renew the patent application for 5th year, okay, 1, 2, 3, 4, 5th year, you want to renew it. Then when do you have to pay the fees? You have to pay the fees before the expiration of 4th year. Okay, you have to pay like 5th year fee, you have to pay in advance, basically, that's what it says. The renewal fee for 5th year has to be paid before the expiration of 4th year from the date of patent. Okay, so then suppose the patent is not granted for 3 years. It takes time, right? You apply the patent, it will go to the examination, it goes to hearing, it will take some time. So then first 2 years, you don't have to pay the fees. But for the 3rd year, at the expiration of 2nd year, you have to start paying the fees. Okay. Suppose you forgot to pay the fees, right? Somehow you missed it, or your paralegal. Generally, law firms will maintain. As individual, we can't maintain. Law firms will maintain. They have all the records. They have softwares specifically to send the reminders to the inventors. Suppose your paralegal forgot, you forgot, somehow you missed, there is a provision to ask for extension. Within 6 months, you can pay it. Sometimes you can pay the fee in advance. 20 years are there. So if you want, you can pay full money. If you have money, you can do that also. You can pay the renewal fee in advance. So what are we supposed to, what is the procedure for paying the fee? There is a form. So you fill the form, you have to quote the number. What is the patent number, right? After the grant, you will get a patent number. That patent number you have to quote. You have to give the date of patent and which year you are paying the renewal fee. 5th year, 6th year, 7th year, whatever, 19th year, you have to mention the renewal fee. Which year we are filing. Remember, if you do not pay the fees, it will be abandoned. The patent, everyone can practice it. It just loses its monopoly. You lose the right. You lose your right by not paying the fees. Okay. Generally, lapse fees. There are some concessions. Are there some exceptions for me if I to restore the patent? Yes, it's possible. Lapse patent, that is because of the non-payment, it can be restored. So what is that? We have a form 15, right? To be filed within 18 months from the date which patent lapsed. Somehow you completely forgot, or you are not. Somehow it missed and you didn't pay the fees. Not even within 6 months, 15 months over. And then suddenly you realize that it's important for you. Then you have to immediately file form 15 within 18 months. After 18 months, it will be abandoned. Then, but not very easy job. You have to provide substantial evidence. Why did you not pay? Is it intentional? Unintentional? You have to somehow prove that it is unintentional. I didn't mean to not to pay. Somehow my records were burnt. My office was burnt. My paralegal did not inform me. My law firm somehow got destroyed the documents. Something you have to show proper substantial evidence. You can't say I was not feeling well. Something happened. Small reasons. No, it has to be real evidence for you to get because it's a big deal, right? If you don't. If the patent is lapsed, anyone can practice it. Everyone can use the patent for their use. So when can you allow them to do that? Only when you don't pay the fees deliberately. you want it, but now suddenly you realized, oh, they are using it, let me go and revive my patent, let me restore my patent. Not possible. If at all really it is unintentional, you have to convince by providing real substantial evidence to convince the patent office saying that this is unintentional. The payment is not done unintentionally, not with deliberately. Restoration solely depends on controller's decision. So, I mean, there is no law, right? You apply evidence. I may accept your evidence, I may not accept your evidence. So, it's exclusively depends on the controller's decision. Controller is the only one who can take a call on this. Okay. Okay. Meena, shall we take some questions, or we'll take the questions at the end? Hello.
Yes, ma'am. Yes. Yeah,
shall we take some questions now, or shall I go ahead and take at the end?
Yeah, we can go for certain questions, ma'am. Participants, if you have any queries, you can raise your questions now.
We have some more cases. So before going the cases, in case you want to ask anything, you can ask me, or let's complete the cases, and once for all we can have a discussion also. Either way is fine.
Yeah, first we will complete the session, later we'll go for the Q&A session.
Question answers? Sure.
Yeah.
Fine.
Thank
Perfect. Perfect. Okay, right. Thank you.
Thank you.
Okay. So now let's look at the cases. I mean, I try to make as interesting as possible. It's very dry. I'm sorry, but the topic itself is so dry. So I tried my best to make it as interesting as possible. Now these are all some cases, some interesting cases, how the courts decide what exactly happened. Let's listen. Let's look at it. Symed Labs versus Glenmark, right? Again, a pharma case. As I mentioned to you, most of the infringements in India especially happens because of the pharma cases. Mostly. Okay. So this case was filed by Symed Labs against Glenmark for infringement of 2 of its patents. So Symed has 2 patents. They felt that Glenmark is infringing their patent rights. So as soon as they get the patent rights, they have to go to district court, high court, or if they are not still happy, they can go to the Supreme Court. Okay. So what happened? What is the story behind it? Symed has invented new process for preparation of linezolid as compared to the earlier existing process, which were very tedious and cumbersome. So Symed has done a lot of work, and they have come up to make a compound they want to prepare. When they looked at the prior art, the existing process was very tedious and cumbersome. It needs a lot of steps. It needs a lot of temperatures, pressures, conditions, etc., etc. But they come up with a very novel process which they can make the drug very easily. Okay. So in an effort to develop more economical, safe, commercially viable process, Symed has developed a novel process. They have not only product, they also have a novel process. So they have 2 patents. They made it and they started making it. In December 2012, they came to know that Glenmark also was making the same drug in the finished form. I mean, see, they are making intermediates, so they could get the final product of Glenmark. They reverse engineered it and they found out the intermediates are same. Okay. So why will Symed leave it? So they work so hard, they are selling. Now their market will be shared by Glenmark, right? They lose their customers. So Symed immediately filed a case. So Symed Labs filed a case against Glenmark for infringement of 2 of its patents. Court said that if there is a prima facie evidence against Glenmark that they misuse the patented products for manufacturing and selling. Remember, these are your rights. As a patentee, you have a right to manufacture, you have a right to sell, and your rights are being violated by Glenmark. So court has looked at both the cases, it heard both the sides, and the court said that yes, Glenmark is infringing the Symed's 2 patents. It was due to this misuse that Symed has suffered irreparable loss. I told you, right? How will the courts decide the damage? They look at so many things. How much loss has happened? So they said it is irreparable loss. So court ordered an interim injunction and on the sale of by Glenmark. So they said, stop. You cannot make it anymore. You have to stop it. Court held that just by providing damages, it will not be enough unless we either injunction. You remember what are the remedies? Either injunction or damages or both. So court thought injunction paying damages alone will not be enough. Right? Just giving them some money is not enough unless they stop Glenmark from making the patented product. So the court said that they gave damage as well as they gave the interim injection. They asked Glenmark to stop making it. Okay. So that is one case of infringement. There are many cases, but I mean, we can't take everything. So this one case I thought I should tell you. Another case is, okay, do you think that you have a grant and you are done? No. Your rights may be at question. Even after the patent is granted, it can be questioned under inventiveness. It can be questioned under patentability itself will be a question. Some cases, we have one case. I picked up some typical cases for you. So what is the basically it says, grant does not absolve the patentee from liability. Okay, I have a grant, so I can do whatever I want. No, not necessarily. You are still liable. Why? How is the case? We will just look at a case. Ringo versus ZTE. Right? ZTE is a Chinese telecom equipment and mobile manufacturer. So they are making this mobile manufacturers. Ringo is a company engaged in the development and commercialization of intellectual property and mobile technologies. So they are basically a non-practicing entity. They are not having any this thing, but they buy the patents, they acquire the patents, and they sue the people who are practicing that, who are infringing their patents. So Ringo filed a case in Delhi saying that ZTE violated our rights. We have a patent, they have violated our rights, so please give them. So court ordered an interim injunction against ZTE's manufacture and use of the patented products. So immediately court gave them an injunction. So this is a controversial thing. I mean, many people commented on this. Court shouldn't have done that. See, they just asked ZTE to stop. How much, I mean, loss for ZTE? They should have done little more homework before giving injunction. The courts cannot give injunction just like that. I mean, this is I'm saying this is how the fraternity thought about it. The court said that ZTE stop making without even looking at the real facts and conditions. So ZTE was upset, right? They spent so much money, they started manufacturing, and this Ringo came and suddenly they said, you are infringing our patents. They're not even practicing entity, there is a non-practicing entity. So ZTE was very upset and they now question the patentability. After the patent is granted, they question the patentability and inventiveness. Where is inventiveness in this? Where is novelty? They started questioning and they asked whether the patent is not valid. Patent is not valid because it is not inventive. They questioned that. So now they went to higher court and the court said that, okay, they formed a committee and they asked for look at the patentability, right? See, at what stage you have a grant, you have a granted patent, but still at the end, when it comes to enforcement, your validity can go back to first stage, first office action, like it goes back. And now the question is whether it is really patentable. Did the controller make a mistake in giving you a patent? It can be questioned back. So this case was evidence of the fact that patentability of the product can be questioned even after the patent has been granted. So I picked up the case for you to just give you an example. Ringo has a patent, granted patent, but now that question, it's a big question mark whether it is really patentable or not. Because ZTE proved so much evidence. See, this is not novel. This is not inventive. They produced so many documents and now the patent is not enforced. If his patent is not valid, how can you enforce it? Right? You have to have a valid patent. So your patent granted doesn't mean that it's the end of the story. It can be revoked. It can be questioned anytime during the enforcement or any time. So validity of patent can also be questioned once the patent is enforced. Be careful when your patent is enforced. When when you're going behind someone, oh, they infringed my patent. Let's be sure that your patent is strong. Okay, that is one case. Okay, the next case is compulsory licensing. I'm just giving some examples. The first case we saw where we talked about that drug intermediate products. That is a real infringement, right? Glenmark really infringed, and the court said that the losses are too much, so they gave an injunction as well as they gave the damages. That is first case we looked at. The second case is Ringo case. What did they do? They have a patent, but the patent is not valid. The patent could be questioned after the grant also. Okay. The next important case is compulsory license. Compulsory license, basically all this, if you look at this, the underlying principle is public health. Underlying principle is affordability of drugs by poor patients. Okay, let's look at the case. Bayer Corporation versus Union of India. This is the first ever compulsory license happened in India in 2012. So government asked, the patent office has asked Bayer to give a compulsory license to NATCO to produce generic version of Bayer's Nexavar, an anti-cancer agent used in the treatment of liver and kidney cancer. Okay, Bayer has a patent. They have a patented product that's called Nexavar. It is used for anti-cancer agent. It is used for liver and kidney cancer. Okay, that is a drug they developed. They have a patent. Unfortunately, they are only 2% of cancer patient population are able to access this drug, right? It was established that only 2% of the cancer patient population had an easy access to the drug, and the drug was sold at a price of 2.8 lakhs for a month's treatment. So naturally, right, only 2%, the rich elite people can only afford this kind of treatment. 2.8 lakhs treatment per month for a patient is not affordable by everyone. Nexavar is being imported within territory of India. What did Bayer do? Bayer has patented it, but they're not making it in India. They're importing it from other countries, maybe from Germany or from US, we don't know. They're importing it into the country and they're selling at that high exorbitant price. So they're not making. So you remember, compulsory licensing, we have not working in India, we have conditions, right? For giving a compulsory licensing, if you're not working in India, if it is not meeting the public interest, if it's not helping the public health, government can go and give a compulsory license, right? So now in this case, compulsory license was given. The patent office jumped in and they issued compulsory license to NATCO Pharma, a Hyderabad-based company, to make the anti-cancer Nexavar drug. You know, the cost of treatment is 8,800 rupees per month, as again is 2.8 lakhs per month. So, right? So it's justified, right? So many of our patients cannot afford 2.8 lakhs. Right? They may have difficulty in having food. So how can they afford this costly treatment? So they just die. Right? So then the government decided that we will have to give them compulsory. This is the first case. It never happens very regularly. I mean, government also it takes care of the patentee. I know Bayer would have worked so hard to get the Nexavar. They would have done so much hard work to reach at the stage to release the drug in the market. But here we have to have a balance between public interest and the interest of a patentee. So the compulsory license was granted to NATCO to make Nexavar. It was settled that 6% of net sales of the drug would be paid to Bayer by NATCO Pharma as royalty. So some 6% is how much money can Bayer make. They are making 2.8 lakhs per month per one patient. Now they'll be getting 6% of NATCO's entire sales, net sales, not profit. They'll get 6% of net sales. Bayer will be getting. That's what it was decided by the patent office. Right? This is a typical case of compulsory licensing. It met the criteria of public interest. It met the criteria of not working in India. It met the criteria of not meeting the affordability of many people of India. Okay, but is it always compulsory license? Can the generic companies use this as a pretext and keep on getting the generic drugs and deprive the branded drug owners? No, not possible. We have a very new recent case. This has especially happened for a COVID-19 case. Okay, Indico Remedies versus Bristol Myers, BMS, right? Bristol Myers is a big company. So now it went to the Delhi High Court during the COVID-19. Bristol has a patent. Bristol Myers has a patent in India, and they have for a drug called as Epixaben. They have a patent for this. Okay, Bristol approached Delhi High Court seeking an injunction against Indico because for infringing their patent and producing a generic form of the drug called Epixaben. So this Indico, what did they do? They also started making the drug. Whereas Bristol has a patent in India, they are selling the drug, and this Indico started making the drug. Okay, Indico approached court saying that they already manufactured 58,000 vials. See their guts, right? How they were so confident that they can sell the product. They can do so. They manufacture 58,000 vials and they are ready. And they said that it is public interest, especially during COVID-19. They said this drug is not available. Bristol is not meeting the requirement. So we need to make. So please keep the public interest in mind and we are not infringing. Give us an allowance, give us a permission to go ahead and release our drug in the market. Then Bristol said, Indico also submitted that the drug was important for treating COVID-19 and it is much cheaper than BMS drug, Bristol Cortis drug. And Bristol argued that Indico had manufactured these strips in anticipation of injunction and sale cannot be allowed due to clear infringement. They thought they can go ahead without being infringed, they can go ahead and make the vials. And they said, if at all public interest is there, what is the right way to go ahead? They have to go for compulsory license, right? They can't they can't release the product without even talking to the government, without even talking to the patent office, without even talking to the patent holder. Indico went ahead and made the product and they were releasing the product. That is not right. So Bristol said, okay, correct. If you are saying that public interest is not met, what is the right way for you to approach? The right way is go for compulsory license. You can't just make just like that whatever you want. Then what is the whole purpose of our patent in India? So Bristol argued. Then the court said, yes, BMS is right. Bristol Myers is right. Court denied Indico's request to sell the drug, saying that no evidence of shortage of the BMS drug. No overwhelming public interest reason. So these are the reasons, right? These are the reasons you can show. But in case of Bayer and Natco, Bayer is not manufacturing in India. Bayer is selling at 2.8 lakhs per monthly treatment. In this case, nothing of that sort. No evidence was there. Such like so, Indico took for granted, and they started making just like that on their own. The court said, no, it's not possible. See, to prove infringement, we need three conditions, right? First, prima facie case. You have to establish a case, first of all, and balance of convenience and irreparable loss. These are the three conditions. If you have these three conditions satisfied, then you can say it is infringed. Supreme Court recently introduced one more factor called as public interest, right? Supreme Court, that is actually in the Act, we have only three conditions. The fourth condition is public interest. That doesn't mean that the fourth condition will prevail these three conditions. So the courts will look at all the four conditions. Public interest is important, right? But not at the expense of these three conditions, right? There is no irreparable loss. There is no inconvenience. So how can an infringer use the patented product? That's what the court said. Delhi High Court said that. No, they denied the permission to Indico's request and they said, it's not right. So they cannot sell the product. So Supreme Court introduced a fourth parameter called public interest. But courts will consider 3 plus 1. Three factors plus also public interest. If the four are there, then you can get a injunction or you can go ahead and get a compulsory license. You can go ahead and manufacture. Not before that. That's what the Delhi High Court said that. So compulsory license is not always right. You can't take the system for granted. Then the whole purpose of Patent Act, the whole purpose of giving a monopoly right will be lost. Okay. Then government use. This is one controversial issue. We have two sections in Patent Act. Actually, one section is 48. Section 48 says what are the rights of a patent holder with the exception of section 47. So patent holder can make, sell, import, etc., etc., etc. But one condition is if section 47 says that if section 47 says that the grant of patents is subject to certain conditions. So there is an exception. For 48 section 48 says that patent holder has so many rights, but on some conditions. What are those conditions? They are defined in section 47 and section 100. What is 47 says? The 47 section says government may import or make or have made on its behalf any patented product or product made by a patented process for purposes of merely of its own use. If government wants to use it, then they can go ahead and make. Though the patent holder has all the rights, government can stop them and they can go ahead and make the patented product. That is section 47. Section 100 says government or any person authorized. Just see the difference between 47 and 48. I highlighted. 47 says only government may use. Section 100 says government or any person authorized by government can use the process. So section 47 has narrower interpretation. Section 100 has bigger, not only government, any party authorized by government licensee, government organization, anyone can go ahead and use a patented product. This is a exemption. Why is this? Basically, country government has sovereignty, right? They have every right over everything. So, and again, it's not for their individual purpose. It's for the purpose of the country. That's the whole purpose of these exceptions in the Patent Act. 47 says government can use. Section 100 says government and any person authorized can do it. So we have two interesting cases. In both the interesting cases, both the cases are very interesting, and result is slightly different in both the cases. Only two cases are there under this category. Okay, so the first one is Garware Walropes versus A. Chopra and Konkan Railways. Okay, so Garware Walropes filed an injunction against the defendant to stop manufacturing, selling, using their patented products. So Garware has a patent. Okay, and this A. Chopra, he has a contract from Konkan Railways, and he is making same product of Garware and giving to Konkan Railways. So A. Chopra is a contractor of Konkan Railways. So he makes and he sells. So now A. Chopra says, see, I am not infringing. I am doing it for government, right? I am not selling it to anyone else. I am making this product and giving to Konkan Railways. Konkan Railways is government organization, and the contract was signed by President of India. So A. Chopra says, I am not infringing. I am not an infringer, right? I am not using for my personal purpose. I am doing for the Konkan Railways. That was his argument. Garware says, no, you cannot. There is no contract between you and me. So government authorized you under Section 47. This is not acceptable, right? Okay, Section 100 is different, and these people argued on Section 47. Government can use it directly, but they cannot assign third party to make it. That's what the argument. Then the Bombay High Court said that even third parties can use the patented invention on behalf of the government. So Bombay High Court said, yes, agree with you. Section 100 allows, but Section 100 also has some conditions. Please look at them. Only on the express authorization obtained by the third party agents from the government. Okay. So did Konkan Railways give express authorization to A. Chopra to make it? That is the first condition. And payment on agreed royalty or remuneration to the patentee under Section 100, subsection 3, based on a contract between two parties. Okay, right? You agree? A. Chopra is not making for his purpose, but did he have a contract to work on this particular invention? Does it say any in writing? And is there any spell about royalties to be paid to Garware? He just started making, he's just giving, and he is getting money from the Konkan Railways. What happened to Garware? He is the patent holder. Where are his rights? Where are his rights being protected? That's what is the argument. So the court made it very clear. Section 47 is different from Section 100. Section 47 restricts the use of patent invention by the government only for its own use. However, government or any person authorized by the government wants to use the invention under Section 100, it has to be under the terms of a contract or license between the patentee and the government agency. First, Konkan Railways has to talk to Garware, get a contract, tell them that we will pay you some royalty, then give it to A. Chopra. So that's what the Bombay High Court said. Am I clear? I'll repeat. So what did the court say? Yes, agree. There are two sections. 47, government can only use, but A. Chopra is using Section 100. According to Section 100, government can make or any agency of government can make. So A. Chopra is a contractor of government. Perfect. So under 100, it's not infringed. But the whole High Court said that then if you want to give to A. Chopra under Section 100, there should be a contract between Konkan Railways and Garware clearly stating that they will be licensing it to A. Chopra to make for them and they will be sharing some royalty. That's what the court said. Okay, so this is one case of government use. One more case is there. Okay, so let's just do the conclusion. So Section 47 requires no royalties to be paid by to the patentee, wherein patent invention is being used by the government. If you follow under 47, you don't have to pay any royalties. Government can use it. But if you are following Section 100, you have to pay some royalty. So why is 100? Because the government can use the sovereign function. So they are the powerful. They have a power, sovereignty, right? The government. So use their power and use Section 100. Exactly opposite thing happened with another case. Chemtura Corporation versus Union of India. Right? Here what happened? This case was heard by Delhi High Court. Delhi High Court was of the view that Ministry of Railways. Okay? Here who was using the invention of Chemtura? Ministry of Railways. They are using Ministry of Railways is nothing but government. So they are qualified as government under section 47 and they can use freely. See, I mean, we don't know how the courts decide the cases, right? So in this case, court said that it's not infringing. The Union of Railways, Ministry of Railways is not infringing the patent because they are using section 47 and it's only for their use, right? The invention is for that's for something for bearings or something like that, railway bearings or something like that. So Ministry of Railways can freely use it without even paying them any royalty. So as per Delhi High Court order, Ministry of Railways has not infringed any patented invention as it is qualified government under section 47. So see, so a whole thing we are learning that maybe if you are working anything with the railways, don't do any hard work because finally it may be acquired by the government without you being paid anything. Okay. The last case I want to tell you is, if you remember, as a patentee, you have authority to license to anyone, right? You can license, you can assign, but be very careful that that license agreement has to be disclosed to the patent office. That has to be registered at patent office. Otherwise, the license is not valid. You cannot enforce it. See, there is an example. National Research Development Corporation, NRDC, right? NRDC basically they collect the research. It's a government organization and they have a lot of inventions. You can go approach them and they'll give you their technologies. They have a lot of technologies. So NRDC has 2 patents to make basically some polymer. They are making ABS resins. They are making ABS resins using emulsion technology. It's a nice patent. They have a nice product. They have 2 patents and they license to ABS plastics. So everything is fine. NRDC licensed the patents to ABS plastics for a period of 8 years. So when they drafted the agreement, they have written for 8 years they are giving. And under the license, ABS paid a lump sum of royalty. Initially, they paid a lot of money according to the terms and conditions and agreed to pay a running royalty as well. There again, there's a big tomorrow, maybe you will be covered under licensing. So either you can pay lump sum and you can have running royalties also based on your sales, based on your profit. All depends on how you write the document. Right? There are no fixed rules, but at the same time, it can't be arbitrary. If anything is within reasonable terms, you can decide. You and your party, both of you licensor and the party licensee can sit together, negotiate the terms and conditions and prepare a licensing document. Perfect. So NRDC was happy. They got a lot of money initially. They also were promised to give running royalty. What happened? ABS failed to pay the royalty under the license agreement. They have agreement. They said that, okay, I'll pay you this much money initially. I'll be paying you every year this much, but ABS failed. So NRDC went and asked for suit, asking for royalty. With interest, they stopped paying us royalty. Please give us a relief. We want the royalty to be paid along with the interest. Then you know what happened? The Delhi court said that, okay, wait, you have a license. Perfect. Is the license registered at patent office? No. So they said license is not valid. Can you believe it? After getting money initially, at the end, NRDC lost everything. Delhi High Court said that there is a section 69 of the Patent Act which says that license agreement must be registered at the patent office for it to be valid. If it is a patent license, it has to be registered at the patent office. Court held that NRDC license was invalid and therefore unenforceable because it was not registered at the patent office. So NRDC will not get any money because patent is not valid. Why is the patent not valid? I'm sorry. But the license is not valid. Why is the license not valid? The license is not valid because it is not registered at the patent office. So sad, right? They have done everything. They got money. They were supposed to get money. They are so innocent. They went to the court. They would have spent so much money on lawyers, court fee. And finally, they lost the case for such a small little overlook. Right? They just forgot to register their licensing agreement with the patent office. Where a right in a patent is assigned or license is accorded in favor of someone, the same is not valid unless it is in writing between the parties, right? That part they have they managed. The license agreement is in place. So first part is fine. The second condition is the document has to be prescribed with it has to be filed with the controller of patents. The court held that license agreement is valid only during the term of patent. Naturally, right? If patent expires, license also expires. You are free to use it. Why do you have to pay them money? So patent license is valid only as long as the patent is valid. That's what the court said. So NRDC lost everything, and ABS need not pay any more royalties to the NRDC. Okay, with this I complete my presentation. So it's a little dry, so I try myself making with a lot of examples, a lot of case law, so that it will give you some interest in this thing. So now let's open the floor for all of you. Anything you can ask me. If you have any questions, any concerns in the previous 3 days, anything related to intellectual property, patent, please go ahead and let's open the floor for question and answer session.
Hello, ma'am.
Yeah, sure. Please.
Yeah, ma'am. Okay. Any question means you can put forth the questions.
Yeah.
Sorry, ma'am. I went for a meeting. So
போல இவங்க மட்டும் வந்தீங்க உட்கார்ந்துட்டு இருக்காங்க அப்படின்னு தோணும்ல. அவ ஆபீஸ் போயிருந்தப்ப நான் போய் இருந்துருவேன். அதனால அது எனக்கு தெரியல. அப்பா கூட பேசிட்டு இது பண்ணிட்டு.
Please mute your phones. Mute your things. You can ask me any questions. You can type on chat box. You can
yes, ma'am.
You can unmute yourself. You can ask me.
Yeah.
Please feel free. Otherwise, we will not know unless it is really you didn't understand anything. Anything, I mean, just let's talk. I'm available not only now.
Yes, I'll see it out. Ma'am, which parameter factors are considered for issuing of compulsory license?
You have just seen that, right?
Yes.
First,
afterwards, afterwards, I think is.
First, foremost important case is public interest, right?
Yes.
If you are not working if you are not working the patent in India, you just filed a patent application, you got a grant, and you are not. Bayer is doing the same thing, right? Bayer is not making in India. They are getting the drug from outside. So that is one condition. You have to work in India, and it is not available to the public at reasonable price, and it is not meeting the requirement. I want 100 tablets. They are making only 1 tablet. So that is one condition. And suppose if you want to send it to a country which is poor country, I want to export. Government wants to send drugs to some country where there is no manufacturing facility. Then we can government can get as a compulsory license. Not always. We can't exploit it always. Yeah, I can see one question here from Pankaj, right? Pankaj Ramdas. Can we use the information from patent for our research use? Yes, absolutely fine. We have an exception called experimental use or research purpose. Be very sure that you are not using it for any exploitation by manufacturing or anything like for your further studies in your lab. Yes, you can use. We have an exception. You will not be infringing. As a student or as a faculty member, you will not be infringing any of the rights of a patentee.
Okay, thank you. Yes, ma'am. Ma'am, we'll take a group photo, ma'am.
Sure.
Yes, ma'am. Participants, kindly switch on your cameras.
You're all tired, is it? None of you asked any questions. For today, dry topics. So that's the reason why I made as interesting as possible by bringing case law. It's interesting to read the case law. I know it's not easy, continuously attending 5 days.
But we are getting more information now, ma'am. Actually, as we are technical people, we doesn't know more on this thing. So
True. So that's what the whole purpose of this course is. Not that you will become masters in intellectual property, but at least you will get some. Now, if someone talks about compulsory license or someone talks about infringement, you know what it means, right? So that's enough. You can get at least that much. That's more than enough.
Yes.
So most of them are faculty members, is it?
Yes, ma'am. Yes, ma'am. Most of them are faculty members.
Research scholars.
research scholars and of different disciplines, ma'am. It's not only of computer science, biotechnology, everything is combined, ma'am.
Good.
Most of them are, and PG students are also there. ma'am.
Okay. Pharmacy too, it
Okay.
seems.
Yes. Yes. Thank you, ma'am. Thank you very much.
Yeah.
Thank you. Yeah. Thank you. Thank you.
Over? Group photo is over?
Yes, ma'am. Yes, ma'am.
Okay. Fine. So can we switch off or anything? Still, I'm open. Anything anyone wants, we can still discuss. And we have another 10 minutes.
Yes. If you have
Unless
any
you are
queries,
hungry.
means yeah. If you have any queries, means just before. Yes, ma'am. I'll see the thing. Thing. Pharmacy too. They want to say.
Yeah, yeah. That's what I
It's for it's for pharmacy college also there. It's of interdisciplinary only, ma'am. So
True. It's very good. So not
because now in MHRD they are asking of patents. Even in when we go for colleges, when you go for NAC, NBA, this is one criteria they have kept. How many patents, whether you have individual patents or patents with college name. So that and all they are asking. So everyone is interested in this area now.
very good, very good. Not only now, anytime you have any questions, organization will be able to give you my contact details. Any question, if you feel you need any help, I'm always available. You can just reach me out through email or you can just take my contact details from organizers. Thank you very much, Meena, for giving me an opportunity to be with the students. I would have loved to have more questions. So maybe they must be hungry. 1:30 is close to lunchtime. So if no questions, then let's leave.
Yes, ma'am.
All the
Thank you,
best
ma'am.
for your future. Do well.
Thank you, ma'am. Thank you very much. Ma'am. Thank you, ma'am.
Bye bye. Bye.
Bye.